Good day. Welcome to our new lesson on Module 2, which is all about international arbitration. In this module, it covers the important features of international commercial arbitration, the rules and the procedures of international commercial arbitration. In this module, it is expected that after the presentation, you could be able to describe the important features of international commercial arbitration and apply its rules and procedures. Generally, arbitration is defined as any manner of arbitration or settling dispute whether or not administered by a permanent arbitration institution. Specifically, international arbitration is a form of arbitration wherein the parties involved came from different states or one of them is situated outside the Philippines. Therefore, to apply the said arbitration, the following are being observed. First, the place of arbitration is determined pursuant to the arbitration agreement. The second is that in any place where a substantial part of the obligation of the commercial relationship is to be performed or the subject matter of the dispute is closely connected. It must be noted that for the purpose of international arbitration, it is the New York Convention, which is the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is the basis or reference for the rules and procedures to be applied as far as the commercial arbitration is concerned. The scope of application of international commercial arbitration are subject to any agreement in force between the Philippines and the other state, and when the place of arbitration is within the Philippines, the same shall not affect any other laws of the country except those submitted to arbitration only according to the provisions of Republic Act 9285, otherwise known as the Alternative Dispute Resolution Act. The rules of interpretation on the international commercial arbitrations provide that international commercial arbitration shall be governed by the model law on the international commercial arbitration. It means that the New York Convention is the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards will be the basis for the interpretations of the rules and procedures pertaining to the ICA. Second, in interpreting the rule, regard shall have to be the international origin of the model law and to the need for uniformity in its interpretation. It means that the model law once again will be the reference or the basis for the rules and procedures in international commercial arbitration for the purpose of uniform system. The court shall have due regards to the policy of the law in favor of arbitration and the policy of the Philippines to actively promote party autonomy in the resolution of disputes or the freedom of the parties to make their own arrangement to resolve their dispute. So it means that the rules provide the freedom of the parties to come up into an agreement at their own expense. The rules provide that it leaves the parties free to determine a certain issue. Such freedom includes the right of the parties to authorize a third party, including an institution, to make that determination. So in here, it simply means that all the rights and privileges are given to the parties involved to utilize any other means for them to freely come up with the agreement that they might enter into. Finally, the parties have agreed or that they may agree or in any other way refers to an agreement of the parties. Such agreement includes any arbitration rules referred to in that agreement. So in here, it means that to come up with an agreement, both the parties are given again with the freedom to utilize any other ways in entering an agreement between them. To validate the form of arbitration agreement, then it must be clearly defined as and shall be in writing according to the rule. Therefore, an agreement is in writing if it is contained in a document signed by the parties. In short, both parties has to affirm the agreement they entered into. Another, an arbitration agreement shall be in writing as well if it is in an exchange of statements of claim and defense, alleged by one party and not denied by the other. So in here, it must be understood that the allegations of one party must be affirmed by another in order to uh, for the party not to deny on the future references. Arbitration agreement shall also be in writing. If it is in a contract, to a document containing an arbitration clause constitute an agreement on the arbitration, provided that the contract is in writing and the reference is such as to make that clause part of the contract. In short, the agreement are clearly defined in a contract of settlement. Now, what composes the arbitral tribunal? Who is the arbitral tribunal? The arbitral tribunal is composed of arbitrators freely chosen by the parties involved, and failing such determination, the number of arbitrators shall be only three. Appointment of arbitrators shall be as follows. No person shall be precluded by reason of his or her nationality from acting as an arbitrator, unless otherwise agreed by the parties. The parties are free to agree on a procedure of appointing the arbitrator or arbitrators. Failure to do so, in an arbitration with three arbitrators, each party shall appoint one arbitrator, and the two arbitrators will be responsible to appoint the third one. However, failure to do so, the appointment shall be made upon request of a party by the appointing authority. And in arbitration with a sole arbitrator, if the parties are unable to agree on the arbitrator, the same shall be appointed upon request by a party by the appointing authority. How about the jurisdiction of arbitral tribunal? Now, take note of the following. The arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement, or any condition precedent to the filing of a request for arbitration. And for that purpose, an arbitration clause which forms part of the contract shall be treated as agreement independent of the other terms of the contract. Meaning, the arbitral tribunal is limited only to rule on its own jurisdiction or in objections with respect to the validity of the arbitration agreement. Next, a plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. In here, it means that any party may raise a plea that the arbitral tribunal does not have jurisdiction, which shall not later than the submission of the statement of defense from the other party. Finally, we have the arbitral tribunal may rule on a plea either as preliminary question or in an award on the merits. If the arbitral tribunal rules as a preliminary question that it has jurisdiction, any party may request within 30 days upon receipt of the ruling, and that the regional trial court will be the one to decide on the matter. So in this particular provision, it means that when a party has raised a plea and when the arbitral tribunal ruled it as a preliminary question, any party may request within 30 days from the receipt of the ruling to the RTC or regional trial court to decide on the matter. The decision of the RTC shall be executory and not subject to reconsideration or appeal. However, while the request is pending, the arbitral tribunal may continue to the proceedings and make an award. The conduct of arbitral proceedings shall adhere to the equal treatment of parties, meaning full opportunity of presenting each allegations or case is freely given to both parties. On the placement of arbitration, the parties are free to agree on the place of arbitration. Failure to do so, arbitration shall be in Metro Manila unless the arbitral tribunal, having regard to the circumstances of the case including the convenience of the parties, shall decide on a different place of arbitration. However, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts, or for the inspection of goods, other property, or documents. The commencement of arbitral tribunal, take note of this, that it shall commence or it shall start on the date on which a request for that dispute to be referred or arbitration is received by the respondent. How about the language to be used in the arbitration proceedings? Well, the answer is that the parties once again are free to agree on the language or languages to be used in the arbitral proceedings. Failure to do so, the language to be used shall be English. The arbitral tribunal may order that any documentary evidence be accompanied by a translation into the language or languages agreed upon, of course, by the parties. The hearing of written procedures, as stated on the provisions, the arbitral tribunal shall decide whether to hold oral hearings or for the presentation of evidence for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials alone. The parties shall be given sufficient advance notice, of course, of any hearing and of any meeting for the arbitral tribunal for the purpose of inspection of goods, other properties, or documents. Finally, all statements, documents, or other information supplied to the arbitral tribunal by one party shall be communicated to the other party. Also, an expert report or evidentiary document on which the arbitral tribunal may rely in making its decision shall be communicated to both parties. The default of a party. Unless otherwise agreed by the parties, if without showing sufficient cause, a default or failure of a party to prove his or her allegation may be under the following situations. In other words, a default of a party means the claimant fails to communicate his statement of claim in accordance with the provisions of statement of claim and defense. And here, the arbitral tribunal shall terminate the proceedings. Next, it is a default of a party if the respondent fails to communicate his or her statement of defense in accordance with the provisions of the statement of claim and defense. And here, the arbitral tribunal shall continue the proceedings without treating such failure in itself as an admission of the claimant's allegation. Another is that when any party fails to appear at a hearing or to produce documentary evidence, then the arbitral tribunal may continue the proceedings and make the award on the evidence before it. Finally, on settlement, the provisions provide that if during arbitral proceedings the parties settle the dispute, then the arbitral tribunal shall terminate the proceedings, and if requested by the parties and not objected to by the arbitral tribunal, record the settlement in the form of an arbitral award. And when we talk about an arbitral award, it means to say that these are the agreed terms which shall be made in accordance with the provisions of form and contents of award, and shall state that it is an award which shall be given to someone who have proved that their claims or their defense has been proven. And the contents of this presentation was derived from the following references. To finally end with the presentation, it is expected with hope that you could able to acquire the important details pertaining to the lesson. Once again, thank you and good day.